All right, to continue from part one. So we talked about the SLAPP lawsuit and this notion of a lawsuit that's intended to try and prevent someone from engaging in free speech, at least if you want to be pejorative about it. So one could definitely characterize Depp's lawsuit as a SLAPP lawsuit because he has to prove actual malice, which is difficult. He has to prove that by clear and convincing evidence, the defendant realized that her statement was false, or that she subjectively entertained serious doubts about its truth, right? And so he has to prove that she published a statement with the knowledge its content was false or serious doubtful for it. And this is a high burden, okay? And that suggests, because again, any lawyer that he went and talked to and asked about it would say, this is a pretty tall order to prove. It's going to require some evidence of her subjective notion that it's false, or was maybe possibly not true. And that's a hard thing to get to. And so there's at least a very real possibility that this lawsuit was engaged simply to prevent her from wanting to go forward with this kind of speech in the future. And so why would you file a lawsuit like this in Virginia? Well, one of the things you would look for is whether or not the state has legislation in the state to try and prevent these kinds of SLAPP lawsuits. Because a lot of states, once they realized that corporations were using these kinds of frivolous or meritless lawsuits to prevent and chill free speech, passed legislation to try and prevent this sort of thing because they didn't want free speech to be limited in their state. And so this is one of the things you look for if you're going to file a lawsuit that could be characterized as a SLAPP lawsuit. Well, how vigorous or how interested is the state that you're suing in trying to prevent these kinds of lawsuits? Okay, so California, which is where both Heard and Depp reside, has very vigorous anti-SLAPP legislation. The burden that he would have to shoulder if he filed this in California would be very high. And it would also make him much more vulnerable to a countersuit and to a much higher recovery if he loses. Okay, DC, which is another venue in which he might file, also has very, very vigorous ties to anti-SLAPP legislation. And their anti-SLAPP legislation is very strong as well because DC Court of Appeals is where a lot of these free speech cases came in the 70s and 80s, which is something that maybe Mr. Koch can respond to, only because he has a lot of experience in the field. So Virginia is a much more favorable playing field, shall we say, for Depp to file a SLAPP type of lawsuit against Heard, and so that's why he filed in Virginia, or at least that's the speculation, and I think it's pretty well grounded in the legal realities here. So Depp is suing Heard for defamation. What is Heard countersuing for? So Heard is suing actually two counts she's trying to file for. One is she's suing under a Virginia law, 8-1 223.2, which gives an immunity for persons for statements made at a public hearing or community third party, which holds in pertinent part. So this is actually a statute in Virginia. It's not anti-SLAPP per se, but it's anti-defamation if you fall within the safe harbor of the statute. And here's how it goes. A person shall be immune, so this is key, a person will be immune from civil liability. There's no civil liability that can be attached to someone who is under this statute. A person shall be immune from civil liability for a claim of defamation based solely on statements regarding matters of public concern that would be protected under the First Amendment of the United States made by that person that are communicated to a third party. Okay? So the immunity provided in the section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. So this dovetails similarly the requirements that Depp has to meet in his lawsuit. He has to show that the statements were made that were false and defamatory, and that she either knew or should have known or had some subjective doubts that her statements were true. And this statute is somewhat similar in the sense that if she can show that the statements she made were matters of public concern, right, and were not made with the knowledge and were true, or at least she believed they were true, then she will be protected under the statute, and she's absolutely immune from civil liability. So that's one of the things she's suing under, is trying to prevent or trying to make the case to the court that this was a matter of public concern, which is domestic violence. That's at least the allegation, and that these statements that she made were not either false or made with reckless disregard for the truth. So that's the countersuit that she's suing for. Okay. She's also claiming her own damages. She's actually filing a separate defamation lawsuit against Depp, which is going to be decided in the same case. Okay. Her allegation is that Depp has damaged her by claiming her allegations of abuse constitute what's called a hoax. Okay. And I'll put the New York Times article, make that available for you so you guys can see exactly what the allegation is. But essentially, her Depp through counsel claimed that the allegations of abuse that were stated in the Washington Post op-ed piece were a hoax, and therefore, by implication, she was lying. So that's the defamation lawsuit. And I'll let you guys see the text of what his attorney said in the New York Times article, so you can get a feel for whether or not you think there's any grounds for it. Okay. So that is, in a nutshell, what the defamation case is about. Hopefully that was helpful for you going forward. What I'd like you guys to do is first read the op-ed piece that Amber Heard wrote, and then hopefully Mr. Katz will give you guys some background knowledge of what an op-ed piece is, how the op-ed pieces are published, how it is that Amber Heard was able to publish this in the Washington Post. And I don't know the details. I don't know whether her agent reached out to a reporter or whether some organization reached out to her and said, hey, would you put an op-ed piece in the paper for us, because we're an organization that cares about domestic violence and we would like you to be a spokesperson for it. Or maybe she's already devoting some charity or portion of her money to an organization, which then tries to open the door to get her some public awareness on the issue. There's a variety of ways these kinds of things can become published. But read the article, read the op-ed piece, see what you think, in particular in the context of Depp's lawsuit, where he says that op-ed piece constituted a form of defamation against him. So one of the things you need to show, which we talked about, read that op-ed piece with that in mind. And do you think that he has a shot of showing it based on the language that you see in the op-ed piece? If you were on the jury and you were given this piece to read, do you believe it's defamatory in its nature? Do you think that by its face, right? Now, he would still have to also show that she didn't knowingly say something that was false, but does it even make the threshold issue of whether or not it is false and defamatory? Okay. All right. So other than that, Mr. Katz has some details in terms of what you're going to do going forward in the day. Go ahead and read that article, and then eventually you'll be able to look at the opening statements of the attorneys. And I'd like you to really critically look at the opening statements, and I'll have another conversation with you further on that. But one of the things to think about what the purpose of an opening statement is to present for the jury what the evidence is going to show. So I don't know if you guys had a chance to make opening statements during your mock trials, but that's your opportunity to tell the fact finder, either the judge or a jury, in this case it's a jury, what the evidence is going to show, and try and present the case in such a way that's favorable to you and makes clear to the jury what they're going to see and makes sense of all the evidence they're going to see. Okay? All right. Have a wonderful rest of your day. I think I got one more thing that I'm going to talk to you about a little later in the day, so you'll get to see me again. And just hang in there, hang tough for this week, okay? One more week, and then I'll be in full-time up to 2:30. Starting next week, and we'll be able to cover some things, go on some field trips, and do some things that I hope are a little more engaging than the past few weeks sometimes have been. So my apologies for that. Just know that I'm thinking of you. Hang in there, and we'll get some time together at the end of the semester at least and get some things done. All right? You all have my email, so you can always reach out to me at any time if you need to, and I'll talk to you later. Take care.